The question is that the bill be now read a second time. Mr. Chris D'Souza. Mr. Shan. Sorry.
Thank you, Speaker, sir, for allowing me to speak. The Parliamentary Secretary has given the government's view on some of the key proposed amendments. I intend to set out the government's position on two major areas of the law which we are amending. One, better protection of vulnerable victims, and second, dealing with sexual offences. We are setting out new offences and enhancing penalties where minors are involved. Some additional conduct of a sexual nature will be specifically criminalized. First, protection for vulnerable victims. We want to provide stronger protection for those who cannot protect themselves. First, we will enhance maximum punishments for offences committed against such victims. And second, we will introduce new offences where such victims are abused. The first category of vulnerable victims, children below 14 years. Secondly, vulnerable persons due to mental or physical disabilities. And third, domestic workers. Penalties for all offences in the Penal Code committed against these vulnerable victims will be enhanced up to twice the maximum punishment prescribed for these offences. Members of this House will remember the case of Annie E. Annie had low IQ. She lived with her so-called close friends. They abused her by beating her daily. They made her do all the household chores. They kept her salary. Annie was not capable of protecting herself. And she suffered for 8 months, and then she died. With the new amendments, if a person like Annie is assessed to be substantially unable to protect herself, then her abusers will be liable up to twice the maximum punishment. They will be charged for the offence of voluntarily causing grievous hurt, so up to 20 years imprisonment. This is in clause 17 of the bill. All penal code offences committed against such vulnerable persons will be made arrestable, regardless of whether the underlying offence is itself arrestable. That will allow the police to intervene quickly. Penalties will also be enhanced for specific offences committed against persons who are in an intimate or close relationship with the offender, even if they are not married. PAVE is a VWO, works closely with a variety of other agencies, including the government. They told me about this case, which was one of the reasons why I decided we ought to change the law here. They helped a lady by the name of Cindy. Cindy had suffered horrific abuse from her live-in partner. She was found by the police in the year 2000, almost completely blind, slash wounds all over her body, broken bones, had suffered horrific sexual abuse over the 8 years. Quite unspeakable. Her 2 young children she had with the abuser witnessed all of this abuse. It took place almost daily. In many serious domestic abuse cases, the abuser exploits the trust of the victim to abuse them. Victims find it often difficult to leave such partners due to the emotional and psychological manipulation which is frequently found in such relationships. So if the offender commits specific offences, rape, wrongful confinement, causing hurt against intimate partners, those in close relationship, the offender will be subject to twice the maximum penalties that are normally prescribed for such offences. These amendments will mean such perpetrators who abuse victims, where the victims trust and depend on them, the abusers will face much more severe punishments. These amendments must be read or looked at together with the proposed amendments to the Protection of Harassment Act, Protection from Harassment Act, POHA, which will be coming up for second reading tomorrow. It means that such intimate partners can get PPOs on an expedited basis, and their perpetrators will get more severe penalties. Because previously, only married partners can apply for PPO under the Women's Charter. Now, under the proposed amendments to POHA, the timelines for getting a PPO will be comparable to that under the Women's Charter. So intimate partners, usually women who are in a relationship but not married, who fear violence, this is a significant step to giving them greater protection. Again, based on parliamentary rules, I cannot go too much into detail on POHA, but my intention is that it must be fast, it must be quick, they must be able to get remedies, and my colleague Edwin Tong will take Parliament through POHA tomorrow. But the Penal Code, the new offences in respect of abuse of vulnerable victims, which lead to death or other forms of grievous hurt, will also be introduced. But going back to intimate partners, therefore, on the one side, offences to be made arrestable and the penalties to be enhanced, and on the other side, easier access to protection orders. Of course, there is the underlying psychological problem, is that if the woman doesn't want to leave and continues to suffer the abuse, then our agencies will have to try and find a way, the VWOs will have to try and find a way of identifying these women, usually women, and then encourage them to take the steps. So now moving on to the leading to death of vulnerable victims. New offences are being introduced where there is serious abuse of vulnerable victims. I can remind members of another case. Daniel Nasser, 2 years old, was abused by his mother and her live-in boyfriend over a period of at least 5 weeks. They kicked and slapped him almost every day. They stomped on his chest. The autopsy found 31 external injuries on Daniel. The court said that the couple had inflicted harm in a ruthless and unrelenting manner. In such serious cases of abuse, which leads to the death of the vulnerable victim, members will find it odd, but lawyers will know it's not easy to convict the offenders of murder. The reason is that it's difficult to show that they had the requisite mens rea, or they knew, or the mental elements were present to meet the requirements for the conviction for murder. Now, I think we have to take a strong stance against such abuse. I'll refer to clauses 83, 104, and 171. The first two offences, causing death by sustained abuse and failure to protect, will cover persons who owe these victims a duty of care. Who are such persons? Persons who have custody, care, charge of the victims. They have a responsibility to protect those under their care from harm. You can refer to clause 83. The third new offense is causing or allowing the death of a vulnerable victim. Victims, as I described earlier, children, domestic workers, other vulnerable persons. The offense deals with situations where two or more persons who are in a position to cause the death of the victim but both deny that they were the ones who caused the ill treatment. In such cases, it is very difficult to prove in court who committed the abuse and who permitted the abuse. Currently, when there is this sort of ambiguity, both could get acquitted while you have a dead child, which is not right, I think. So deaths resulting from natural causes, accidents, will not be covered. But otherwise, if you stood by and you allowed the child to be abused in this way, you can be charged. UK and Australia have similar offences. A case from the UK is illustrative of the kind of situation we are thinking about. I refer to R.V. Ikram from UK, 16-month-old, a year and 4 months, boy, he died. He was living with his father and father's female partner. The boy suffered 21 different injuries within 48 hours before his death, including a fatal fracture to the left femur. It occurred within 12 hours prior to his death. It was established that only the father and his partner were present during the period when the fatal injury was inflicted. Father had been absent for around 2 hours. Both the defendants were charged for murder, and both claimed that they did not know how the injuries were sustained. In Singapore, under our proposed amendments, father and partner both can be charged for causing or allowing the young child's death. So clauses 83, 104, and 171. There has been some feedback, concern that persons who are themselves victims of abuse could nevertheless be held liable for their inaction by failing to protect a vulnerable victim or causing or allowing the death of a vulnerable victim. For example, a husband, right, violently abuses his wife and his children. Concern is that the abused wife may herself be found liable under this offense if she did not intervene to prevent her husband from abusing the children. This is even though she may not have really been in a position to intervene, and that should not be the case. The clauses in the bill require the court to consider past or present experiences of those of the accused persons, of abuse as well. The court needs to determine the steps the accused person could have been reasonably expected to have taken to prevent the abuse of the vulnerable person. Under the amendments, Daniel Nasser's abusers, the very people who are supposed to protect him, could be liable for the new offense of causing death by sustained abuse and causing or allowing Daniel's death. Now I'll turn to the review of sexual offenses. There are amendments to better protect minors, and there are amendments creating a new categories of sexual offenses. First, minors. Members of this House may remember the case of Joshua Robinson. He was 39 years old. He met two 15-year-old girls on social networking sites. He pressured them to send him nude pictures of themselves, and he also met up to have sex with them. Currently, I mean, some members might find this surprising when they think about it, asking for and receiving nude images by consent from a 15-year-old is not an offense today. I mean, you think about it. He also filmed their sexual encounters. When his house was raided, they found obscene films, including more than 300 films of child pornography. After he was arrested and released on bail, when he was on bail, Joshua Robinson showed a 6-year-old girl explicit videos of his girlfriend performing sexual acts on him. At present, that's not a separate category of offense. It has to come within, it does come within the rubric of showing an obscene film. But I think members will agree we should criminalize it separately and clearly, rather than treating it as a just showing an obscene film. I think the action and acts are heinous in themselves beyond the showing of the film. He was eventually sentenced to imprisonment for having sex with minors because both girls were under 16, making and possessing obscene films and showing an obscene film to a 6-year-old girl. I think members will agree getting the two 15-year-old girls to send nude photos should itself be criminalized, and showing this obscene photo of video film to a 6-year-old should be treated with more severity by a separate category of offense. So I said at that time that we needed to look at criminalizing some parts of this conduct which were not at that time caught, and increasing the penalties as well, to ensure that people like Joshua will be dealt with more severely through higher penalties. So the new offenses rubric of exploitative sexual activity with minors will deal with sexual predators who exploit young people. The age of consent for sexual activity is 16 years old, but there are situations where slightly older minors, 16 to 18 years, may actually be exploited for sexual gratification by persons who are in a relationship of trust with the minor. In such cases, the young person's consent, and we are talking about 16 to 18, that young person's consent is, in my view, compromised. We are therefore introducing offences involving sexual exploitation of minors of age 16 or above, but below 18, where sexual penetration is involved, sexual grooming is involved, sexual communications are involved. The sexual exploitation offences by persons in relationship of trust with minors who are below 18 years of age, 16 years of age, we will enhance the existing penalties. We will peg them to those for non-consensual sexual penetration. So there are two parts to this definition of exploitation. First, in considering whether the accused is in a relationship that is exploitative of the victim, the court will be required to consider the age of the minor. The younger the person, the victim, the more susceptible to influence he or she will be. Second, the difference in age between the accused and the minor. A large age difference may result in the victim viewing the accused as an authority figure, allowing the accused to exert significant influence over the victim. Third, the nature of the relationship. If the accused initiates sexual communication or activity, it is likely that the intention of the accused, particularly if it is done very early in the relationship, it's likely that the intention was to make use of a power imbalance in the relationship to exploit the victim for his sexual gratification. Fourth, the degree of control or influence exercised by the accused over the minor. The greater the influence by the accused over the minor, the more the minor's will may be considered to be compromised. The use of violence or coercion by the accused will be considered to be amongst the indicators of control or domination over the victim. So, in short, a key factor in determining exploitation is the presence of a power imbalance between the accused person and the minor. There are other jurisdictions which take a different approach. For example, the UK and some states in Australia have an exhaustive list of relationships. Sexual activity between adults and minors in such relationships is prohibited. We have adopted this as the second part of the definition of exploitation. A list of specified relationships has been included in the law where these relationships exist between the accused and the minor. There will be a rebuttable presumption that an exploitative relationship exists. What are these relationships? They involve an adult who is in a position of responsibility, authority, or influence over the minor. Will include teachers, teacher-student, doctor-patient, parent-child. Where the relationship between the accused person and the minor is not in this list, the court can still find that a relationship was exploitative based on the assessment by reference to the first part of the definition. So if you look at clauses 113 and 121, those are set out. I'll now turn to predatory conduct against minors. The amendments and new offences take into account developments in technology which have enabled predators to increase their number of victims and the speed with which they can groom minors. We are seeking to lower the threshold for the current offence of sexual grooming. We are reducing the required instances of prior conduct from 2 to 1, and we will lower the age floor of the offender from 21 to 18, clauses 116, 117. New offences will be introduced. Sexual communication with minors, I spoke about this earlier. Showing a minor a sexual image, I spoke about this earlier. Sexual activity in the presence of a minor, clause 117. So this will allow us to criminalize predatory behavior like Joshua Robinson's, including asking minors to send him nude images. There will be, of course, other types of conduct, sexual experimentation amongst young persons. It is not the intent of these new offences to target those group of persons. The intent is to prevent predatory conduct. AGC will, of course, have to exercise prosecutorial discretion in determining whether it is in the public interest to prosecute. If it's between boyfriend and girlfriend and they are of a certain age, very young, and it's not exploitative, it shouldn't come within this provisions. So covering the spectrum of predatory behavior allows us to intervene early to ensure that our children are protected before the offender has time to meet them and prepare them and commit additional, more serious sexual offences. That could cause, of course, greater physical and psychological harm. Next, child abuse material. I said in this House last year, we were looking into drafting specific laws against child abuse material. Apart from sexual abuse, some children are physically abused. They are tortured as well. And terrible harm is caused to these children who are used in the production of such material. We must do what we can to protect them. It doesn't happen much in Singapore, but we are going to make this extraterritorial in some ways. We have criminalized the spectrum of offences to deal with every person involved, from consumers to the producers of such material. So we will also cover realistic depictions of children, meaning the depictions which are so closely resemble that of actual children, such that if an ordinary person looks at the depiction, they can't tell whether this is real or a depiction. Inclusion of these realistic depictions of children will prevent an accused person from arguing that a depiction is computer generated when in fact it involved an actual child. The offences of using or procuring a child for child abuse material, production of child abuse material, these will be made extraterritorial. So the offences will cover Singaporeans and PRs who commit such offences overseas. Of course, it will cover them if they do it here as well. And any person who is in Singapore and commits these offences against a child overseas, and any person who is overseas and commits these offences against a child in Singapore. So that's in clause 120. Next, child abuse material which depicts fictional children. This is dealt with under section 292 of the Penal Code. The offence criminalizes sale, distribution, exhibition, production of obscene material. Possession of such material is not criminalized under this provision. We we want to enhance punishments under Section 292 when the obscene object depicts minors below 16 years old. The maximum punishment is sought to be increased from 3 months to 2 years of imprisonment. And a new offense criminalizing possession, distribution, importation, production of child sex dolls will also be introduced. These refer to anatomically accurate dolls or robots with features which resemble a minor below 16 years old. These dolls are produced and used overseas. We are prohibiting them because of the concern that they may reinforce tendencies which can then develop into actual harmful acts towards children. Next, technology has facilitated the commission of sexual offenses such as voyeurism, cyberflashing, distribution of intimate images, often referred to as revenge pornography. And there has been an increase in such cases. These offenses are currently criminalized under the Films Act and Penal Code. We want to create specific offenses in the Penal Code to provide a proper framing for such offenses and adequate punishments. Voyeurism involves observation or recording of someone doing a private act without the person's consent. Some of the more commonly known forms of voyeurism include upskirting, downblousing. Recently, there has been a spotlight on these offenses because of the incident in NUS involving Mr. Nicholas Lim. These offenses are currently dealt with under insulting of modesty in the Penal Code and Films Act. The current laws, in my view, do not adequately address the range of offenses, including voyeuristic recordings and the distribution of such material on the internet. So we propose to introduce specific offenses involving voyeurism, which will define the offending behavior and provide for adequate punishment. The proposals, members know, as I said earlier this afternoon, well predate the incident involving Mr. Lim. In fact, the bill was tabled in Parliament before that incident came public. And it was before that incident took place as well in terms of working on it and drafting. We have also introduced a presumption where the accused person has made a recording of another person doing a private act or of their private parts. It will be presumed that the person recorded or observed did not consent to the observation or recording. Sometimes there are evidential challenges because you can find the images, you can't identify who the person is. This will get over the legal burden, and presumption is that there was no consent, and the accused can then say why there was consent. The new offenses will criminalize peeping Tom behavior, making of voyeuristic recordings, distribution, possession or gaining access to such recordings. Also, modifying any part of a building structure to make voyeuristic recordings will also be criminalized specifically. This was recently reported in international media as being a very serious issue in South Korea. The proposed maximum imprisonment terms for the observance, possession, and making of such voyeuristic recordings is now going to be 2 years if the bill gets passed. That's double the current maximum 1-year punishment for the offense of insulting modesty under Section 509. There is, I think, a clear need to deter the proliferation of voyeuristic recordings. So distribution of voyeuristic recordings will attract a higher punishment, a maximum imprisonment term of 5 years if you go around distributing this. The court may also impose a fine and caning for these offenses. Say, refer to clause 120. We have also introduced a new offense to criminalize sexual exposure, which is commonly known as flashing. There has been a prevalence of this. Persons intentionally send unsolicited pictures of their genitalia over social media or messaging platforms. That will be criminalized. Penalties for that offense will be enhanced where the victim is below 14 years old. Distribution or threat to distribute intimate images. We will introduce new offense for distribution, threat to distribute. It's colloquially known as revenge porn. Intimate images could become widely shared and on platforms may be impossible to completely remove, and they have the potential to cause great harm to the victim. The offense will exclude images such as caricatures, cartoons of a person performing sexual acts. So lewd caricature of a person may amount to harassment, but not something that could be mistaken as an intimate image of the person depicted. Maximum penalty for this offense would be imprisonment up to 5 years with the option of fine and caning. Where the offense is committed against a person below 14 years old, imprisonment will be made mandatory. New offense will also cover cases where a person unlawfully accesses databases or recordings that contain intimate images. That's also in clause 120. We are also introducing a new offense, procurement of sexual activity by deception, relating to two types of conduct. First, the use of sexually protective measures, and second, the presence or absence of sexually transmitted diseases. In some countries, cases have emerged, men agreeing to use a condom but secretly removing it before or during sex. It's known as stealthing. In these cases, the quality of the consent provided by the victim would be compromised by the deception. We have identified, and also if a man, usually men, don't identify or mislead the partner on their sexually transmitted diseases, that's also covered. So we have identified these two types of deception because they carry serious risks to the victim and represent a greater violation of the victim's sexual autonomy. So you can refer to clause 119. We will continue to assess whether there is a need to expand this offense to cover other circumstances in the future relating to consent. Mr. Speaker, sir, these enhanced penalties, the new offenses created, I think will help to better protect vulnerable victims of sexual crimes, and reflects our commitment to protect such persons. The amendments we are making today strengthen our laws. They will help ensure that Singapore continues to be a safe home for our people, particularly women, children, vulnerable persons. Thank you, sir.